Welcome back to the Friday Five for August 2nd, 2024. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. On Fridays, we like to take a quick look at 5 questions from the week in about a 5-minute video. Maybe these are questions you've had before. Question number 1 this week: where will my business be sued? So in this case, I spoke to a business owner who had been receiving debt collection notices from a debt collector. Now, that debt collector is located in Minnesota, which is why the business reached out to me. So the owner said, well, I figure I'm going to get sued in the state of Minnesota. Now, the twist to this, of course, is that this person is not located in Minnesota, and we don't know if the people who are suing her are located in Minnesota or not. It's just the debt collector who's located in Minnesota. So what we need to do first is actually look at our contract with the company. So the underlying debt, the people you had the contract with, and look for the jurisdiction or the venue clause. And that will tell you what state you'd be in if there was going to be a lawsuit. So just because the debt collector may be in a certain state, it doesn't mean that that's the state you'll be sued in. And in fact, you should understand that most debt collectors are not attorneys, so they're not going to be the ones suing you anyway. It'll be somebody else. It'll be a law firm, usually in the state where the venue or the jurisdiction clause says a lawsuit has to be brought. Question 2 this week: how many LLCs do I need for my rental properties? So in this case, a client called me and had 5 different rental properties and wants to set up LLCs for the properties. And this is a very standard question we get about, if I have multiple properties, how many LLCs should I set up? And I like to think of it as there's a good, better, and best system. So on the good level, we want to set up an LLC at least, and that would be setting up one LLC for all 5 properties. The better thing to do would be to set up 5 LLCs, one for each property, because what that does is allows us to limit the liability per property so that if you have a lawsuit on one property, it doesn't bleed over to the other ones. So we've done good, we've done better. The best scenario that I normally will recommend to my clients is to actually do a holding company LLC to then own the 5 different individual property LLCs. This will give us a little more flexibility on the ownership structure as far as the initial LLCs are all individually owned by that holding company LLC. And then if you have an estate plan in place, you can actually create a trust to hold your interest in that holding company LLC. So we can actually set up a whole process that really protects your interests for the long run and essentially creates a succession plan so that those rental properties can keep going on without having to go through probate after you die, and they can be managed for your children's benefit, and they could keep all that rental income. Question 3 this week: when do I need to file my beneficial ownership statement with FinCEN? So as you've seen in videos before, the Corporate Transparency Act went into effect on January 1st, 2024. If you file a new business in 2024 and you qualify for the FinCEN reporting requirements, you have 90 days to file your FinCEN beneficial ownership statement. Once we get to 2025, businesses formed in that year will have 30 days. So if you form in 2024, you have 90 days. If you form in 2025, you have 30 days. If you formed before 2024, you have until the end of 2024 to do your filings. And I give this all with the caveat that there have been lawsuits against the government saying that the FinCEN is unconstitutional. And there was a lawsuit in Alabama that did make that finding and has stayed the enforcement of FinCEN's requirements for now. But I would not rely on those lawsuits as a way to avoid filing. I would just keep an eye on the lawsuits and see what happens with the Corporate Transparency Act. And if down the road it becomes unconstitutional, then you won't have to do the filing. But make sure you're paying attention to the current status of the law when you're setting up your new businesses. Question 4 this week: should I wait until I get married to sign my will? Is a very common situation where a couple are getting ready to get married. We're getting all of our documents in order. In this case, they've already done a prenuptial agreement as well, and they said we should probably do our estate plan. And so in doing the estate plan, the question is, should we do it right now or should we do it after the wedding? And my recommendation is usually do it now, because you never know what's going to happen. God forbid you don't make it to your wedding day and we need to distribute assets. And in this case, the parties actually have a few kids together prior to the marriage. So we want to make sure those children are protected. And then what you can do is after you get married, you can execute what's called a codicil, which is a simple will amendment that simply adds to the will the fact that you are now married. And it's a simple update. And so when I work with clients, we just factor that into our estate planning documents that will need a codicil after they get married. But I do recommend that even if you have an upcoming wedding, and in this case, they're changing their name, we at least start and get that will in place, because you never know what's going to happen between now and your wedding. Or let's say you go on your honeymoon and something happens before you get back. So make sure you get your will signed. And question 5, what other estate plan documents do you recommend besides a will? So I've had a few conversations with a former client, and we've been going through the different scenarios, and the client was focused solely on the will. That's all that he had been thinking about, was just creating a will. And as we got to talking about the package of documents that comes with it, he said, wait a second, I hadn't thought about that. What else comes with that? Well, we look at things like a healthcare directive, meaning if you become incapacitated, somebody can make decisions for you. A HIPAA authorization, allowing that person who's making decisions to have access to your medical records. We can do a living will, which would be if you become in a vegetative state, do you want to be resuscitated? We can have a personal property memorandum if we have small bits of family items that we want to go to a certain person. We have a financial power of attorney, which is somebody to make financial decisions for you if you become incapacitated. So there's a variety of different documents that goes into your estate plan. And a lot of people confuse estate plan with will, thinking they're the same thing, when in fact the will is just one document in your estate plan. So you want to make sure you understand all the different documents that are going into your plan, and make sure you're planning accordingly so that your will and your other documents reflect your wishes. So that's it. That's our 5 questions for the week. If you like this video, you can hit the like or the thumbs up button below. You can head on over to YouTube to subscribe for future episodes, or go to ayerslaw.tv.com. You can submit a question for future episodes at the link in the comments below. You can always go to my website, andrewmayers.com, for a legal strategy session. And I hope you have a wonderful weekend wherever you are.